You want to introduce a photograph of your injuries at trial. Is there ever an instance where the defense attorney will refuse and fight with us about admitting that photograph into evidence? You want to know the answer? Come join me on this walk through the neighborhood as I share with you exactly the answer to that question. I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. The answer is yes, there are some instances where the defense attorney refuses to voluntarily allow us to go ahead and put a photograph of your injuries into evidence and show it to the jury. Now, why would he do that? What would prompt him to say, hey, I don't want the jury to see this photograph? I'll tell you in what instance that might happen. So let's say you suffered horrible injuries because of a careless doctor. And now you brought a lawsuit against this doctor claiming that he was careless and that his carelessness caused you harm and injury, right? And now we have a medical expert to support our claim. Okay, your injuries are so bad that when you show them to someone, they want to gag, they want to throw up. Why? Because they are so horrific, they are so horrendous, and honestly, they are so nauseating to look at for anybody to see, even an experienced doctor, even a doctor who deals with this on a regular basis. It is so horrific and the injuries look so terrible. Now, we want to take lots of pictures. Why? Because we want the jury to see the extent of your injuries. I'm not going to have you disrobe and take your clothes off in the middle of the courtroom to show the jury what you went through, to show the jury all your injuries. It might be different if you had a scar, let's say on your arm, on your face, on your leg. That's different. But now, in a sensitive area, I'm not going to ask you to disrobe during the course of trial. So now what do? We have you take photographs. The doctor will take photographs with the intention that now we want to show these photos to the jury during the course of trial. But you should know something. Before I can do that, I actually have to take these photographs and give it to my opponent. So what we do is, as soon as we get these photographs, we make copies of them, and now we send it to our adversary. And we say, hey, just want to let you know we intend on using these photographs at the time of trial. Now we ultimately get to trial 2 years down the road. During the course of trial, you are up on the witness stand. I now have you explain what your injuries look like to the jury. And then I say, hey, Mrs. Jones, I know it's kind of hard for you to express in words exactly what your injuries look like. You have photographs, don't you? And she said, yes, I have quite a few. And did you take those photographs at the time that these injuries were visible? Yes, I did. And did you use your phone to do that? Yes. And during the course of this case, did you provide me with copies of those photographs? Yes, I did. And are those photographs accurate? Yes. Do they represent the extent of your injuries at the time you took them? Yes. And do you have many photographs showing the timeline and the sequence of what happened from the time the injury occurred all the way up until today? Oh yes, of course I do. Great. So now let's go through some of these photographs. Now I ask you to look at this photograph. Let's mark this for identification purposes. Now, you should know I haven't shown this to the jury yet. I can't show it to the jury yet, but I can have my client talk about it, and that's what I'm going to do. So we have it marked for identification. Your Honor, can I mark this for identification, please? Yes, you can. Okay, Mrs. Jones, I'm showing you a photograph which is marked as Plaintiff's 1 for identification. Tell us what's contained in that photograph. And now she begins to explain in detail of exactly what's contained in that photograph. And it clearly is horrible. Looks terrible, looks awful. And now, after she's done explaining what's in that photograph, so now here's the magic question I asked the judge. Your Honor, at this time I offer this photograph into evidence. And now the judge turns to the defense attorney and says, show it to your opponent. And they say, Judge, I've already provided this photograph to my opponent and I'm showing it to him now. He looks at it, immediately stands up and says, Your Honor, I object. And the judge says, why you object, counselor? He says, because this photograph is highly, highly prejudicial. And I am shocked. For the first time I hear these words out of this attorney's mouth. What does that mean, that the photograph is highly prejudicial? What he's trying to say is, hey judge, if we show this photograph to the jury, the photograph will generate so much sympathy for this patient that there's absolutely no way we can get a fair trial. That's what he's trying to say. Now, what does the judge have to do? The judge has to see the photograph, and he's going to decide for himself whether or not what the defense lawyer is saying is true and accurate. So now, hand that up to me, counselor, the judge says. Now I march up that photograph up to the judge. The judge looks at it and makes an immediate ruling about whether or not it's appropriate for the jury to see. If the judge thinks it is not appropriate for the jury to see, he will say, you're right, counselor, objection sustained, which means This photograph is not coming to evidence for the exact reason that you just described. It is prejudicial. And getting this in front of the jury would create more prejudice than the benefit of showing it to them. So if the judge refuses to allow me to get that photograph into evidence, you know what I'm going to do? Great. Now I'm going to take photograph number 2. Judge, I want this marked as exhibit number 2. And now I will ask my client questions about the second photograph, and the third, and the fourth, and I'm going to keep going. Why? Because it also gives the jury the impression that every time my opponent jumps up and objects, what's he trying to hide? Why is he refusing to allow these photographs to be shown to the jury? And now the jury gets in their mind, hey, maybe this is important. What is it that he's trying to prevent us from seeing? And it's just a perception, so that even though the judge will not allow the jury to see these pictures, they get the sense that, hey, there's something really serious here. There's something that he doesn't want us to see. We're missing pieces of information that we should be allowed to see. So why do I share this great information with you? I share it with you because there are instances where my opponent will jump up and object to a photograph being admitted and offered into evidence so that the jury can now see it. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.